As Rutger introduced me, I'll be discussing kind of U.S. tax jurisprudence from U.S. tax court perspective and comparing it to the OECD approach to risk allocation in this current era of taxation. Thank you for having me. It's glad to be here with Romero and Svetlana and Rutger. I did my master's thesis at UFA with Rutger, so it's very nice to be back here presenting. So thank you very much for having me. I'll start off here with sort of a simple diagram discussing kind of taxation. Imagine the smiley face is kind of an individual, and this sack of money right here is just accretion of wealth, be it any type of income coming in. Traditionally, the individual is taxed, but if you put a corporation around this income or a source of money, the company would be taxed. I think these are sort of basic legal fictions that we acknowledge in taxation. But even if you kind of go into a higher level of capitalism where you have the individual being taxed here, or the individual managing the income coming in, still that entity would be taxed here. But as we'll go into a little bit of detail, looking at the OECD's risk allocation framework, we kind of we'll see that maybe it's the entity managing the risk and having control over this source of income that will be taxed. So this the normative analysis that I'll be taking in this presentation comes from actually Rutger Hafkenstein's interpretation on Action 9, risk allocation not so functional. The BEPS Action 9 framework sort of provides a definition of risk management, and the following bullet points are sort of paraphrases of the 6-step plan that are available in Action 9. The first step is to identify the economically significant risks with specificity. You basically identify the risks, you analyze the contractual assumptions of those risks, you do a functional analysis, you interpret that functional analysis, then you do a risk allocation, an important step 5 here, and then you price accordingly. And like I said, this is just a summary. Of course, the BEPS action goes into quite some detail. But step 5, based on this normative analysis, sort of disregards steps 2 through 4 because it says that the contracts will only be followed if the financial capacity to assume the risk is present. So otherwise, the intercompany contracts will be disregarded. So in a sense, a contract will only be followed, that step 2 contract, if the definition of risk control that the BEPS project has outlined is mirrored in the contract. So step 3 here is key in determining what control and control over risk is. And if you go kind of into a little bit of detail here on this step 5 interpretation of control, it depends on the definition of control over risk, and that definition kind of rests on the party taking on the assumptions of risks. In other words, it's the party with the capability to make decisions, aka the party that has the ability to absorb risk. These are kind of just a few quotes taken out of the BEPS Action 9 report as this article is interpreting. So based on this definition, this step means that the contractual allocations will only be followed if the functionality test proves the contracts. In other words, Hafkenstein is sort of providing an interpretation that the contracts will be followed only if the risk is allocated to the company that is assumed to have access to capitalization, aka access to funding. And as you recall with that smiley face interpretation, it sort of seems to indicate that the individual here, the smiley face will be kind of the one taxed, not where the income is sort of being, where the money is. And that seems to change the framework of taxation. So that's kind of the BEPS framework. And now I'll go into the US tax jurisprudence, and I'll go into a little bit of detail here with this Veritas v. Commissioner case for a number of reasons. It represents the common structures that multinationals that appear in the US tax court frequently have taken. And it was also the first case dealing with cost sharing arrangements. And there are also 2 other cases that I'll discuss that cite to Veritas, Zilinex and Amazon. And we'll go over those after going over Veritas. So in a sense, this Veritas case is seminal. And as I mentioned, Veritas represents kind of this common structure that other cases exhibit of what many of these US multinationals take to create a typical structure for entering, let's say, the European market, as was part of the facts in this Veritas v. Commissioner case. So with a CSA agreement, you have an entity doing a buy-in payment that would enable that entity to license their IP. Frequently, these structures can be used to allow risk to be assigned contractually within the affiliated group, with the objective to bear such risks. And the question that the IRS has to face sometimes in these cases is whether the risk in the related party transaction and in comparable transactions are in fact comparable, as is a frequent question in transfer pricing in general. So this is part of the difficulty that transfer pricing cases at the US tax court try to figure out. So this slide here kind of briefly outlines the facts and the exam posture between the taxpayer and the IRS. Just the tax years in question are 1999 through 2001. Just a brief history on Veritas. Like Veritas is at this time was dealing a lot with data loss, corruption. These are things, in fact, almost all computers have some sort of ability to, deal with data loss, hard drives, things of that nature. It's not just hard drives, but software that has to deal with these computing functions. So Veritas, like many multinationals, used to primarily distribute into the European market through competitors and distributors, entities that didn't have a connection to Veritas, except through these contracts. They'd license to a third party, and that third party would, pay a royalty rate and license, and those licenses would bring some income for Veritas. But as is frequently the case in other cases as well, Veritas did not have control of these sales, marketing, when distribution would occur, and so on. And that was how Veritas made its income. So Veritas over time determined that it should enter the European market with more of its own entities, and that would improve its sale. This is kind of the outline that's provided in the Veritas case. The US tax court kind of gives the business background, the channeling and distribution functions that Veritas had to go through. So part of this idea that Veritas had to enter the European market was creating a CSA, the cost sharing arrangement with an Irish entity. That Irish entity had to do a buy-in payment. And basically the issue before the court was whether Veritas Ireland had made an arm's length payment to Veritas as in consideration for those intangibles transferred to Veritas Ireland in connection with that CSA. So in general terms, was the lump sum payment made by that cost sharing participant, that Irish entity, for the use of the intangibles that was made through the cost sharing arrangement, was that an adequate sum? As you can see here, that tax years in question, in fact, Veritas had made a buy-in payment of 118 million. The IRS determined that it should be 2.5 billion, and that the Veritas should or owed 704 million plus 54 million in deficiency. So 118 million is a different number from 2.5 billion for the use of the intangibles in the property. Those intangibles, as they occur, as the other cases we'll look at, they include R&D teams, access to the marketing team, the US-based marketing team, distribution channels, customer lists, trademarks, brand names, sales agreements. And the IRS thought that 118 million was not accurate and wanted the buy-in payment to be 2.5 billion. So here at the bottom, we see the IRS analyzes the intangibles in the aggregate, and the taxpayer analyzes the intangibles individually. So the taxpayer's royalty rate being licensed to its to the entity that has in Ireland was initially determined on kind of an internal comparable transactions where the taxpayer had licensed the exact same intangible to unrelated parties. As we had mentioned earlier, there were distribution channels where Veritas would sell to the European market through unrelated parties. So, but there was a difference. None of these internal comparables that the taxpayer licensed had the same full range of rights that were bundled together and made available through the cost sharing arrangement. So you can imagine you license a little bit to one, entity, third party A, you license a little bit more to third party B, but you don't license everything through one third party. So the IRS was analyzing all of these intangibles that were being shared with the Irish entity in the aggregate, and the taxpayer was analyzing them individually. That is to say, we'll analyze trademarks, we'll analyze the sales agreement, we'll analyze distribution channels, brand names, and so on. So the IRS is analyzing intangibles in the aggregate. And just to go into this comparability, the analysis, the internal transaction, which the taxpayer based its determination of the transfer pricing, the IRS says that the rights granted to each third party are effectively narrower, and that kind of makes logical sense looking at looking at the outline of this argument, in the sense that those made to the Irish affiliate, the CSA, and the IRS is saying that you can't really compare the various rights separately, so you have to do it more of an aggregation approach. And the word that came about a lot in the opinion is these synergies. There's a lot of bundled together synergies that come together as one rather than individually. So the IRS, in a sense, this aggregate theory is arguing that there's a full sale being given over to this Irish entity. And as I mentioned up here, they have 2.5 billion. Actually, during trial, they conceded, the IRS argued that maybe the appropriate buy-in was actually less, 1.7 billion. Somewhat of a side note, but it was mentioned in the case as well. But it shows that there's some debate as to what this buy-in payment should be. So Veritas Ireland gets all these intangibles, and the court has to analyze which procedure is correct. And before I go into the steps of analysis here, it should be noted, as Professor Hopkinson had mentioned at the beginning, the IRS had regulations in 1968. They revamped those regulations in the mid-90s, as this Veritas v. Commissioner case was decided on those regulations from 1995. And those shouldn't be confused. Even though it was the same year that new regulations came out, it was still set in the year of the 90s regulations. And there were new regulations in 2009, but it's not decided on those regulations. So the court followed a five-step analysis based in those 1995 regulations. It starts off with functions, and then it looks at contracts, and then it looks at third party, it looks at risks, and then it looks at economic conditions, and fifth, it looks at properties and services. And so this is kind of the comparability analysis. You do benchmarking for each one of these items, and it's a factor analysis. One is not dispositive over the other, but you kind of look at it holistically. And so the court focuses on the comparable contractual terms before the economic conditions. And it's probably worth noting that this is probably different than the BEPS analysis that we had looked at previously. We'll get in 2 slides, I'll get into comparing those two frameworks, but going a little bit deeper into this, the key point in the court's analysis is that the problem with the IRS's aggregation theory was that valuing the risk and the assets as if in the aggregate sort of assumed that they had a perpetual life. But as sort of both experts concurred in the court case, the software has a short valuable life. It only lasts for a few years. And as a result, the court said you can't really aggregate these all together, because that assumes that all this software, all this data backup would be perpetual. And I think that makes sense. Software doesn't last forever. You have software after a few years, it's not as valuable as it used to be. There's frequently updates. So this is the framework. And this framework is carried through in other cases as well, as in Amazon and Zillinex. And again, this was decided on the 1990s regulations. So the court kind of looks, they say, we have to look at the intangibles here. The technology and the IP only lasts a few years. The economic life ramps down. It's 2 to 4 years. It ramps down from 33%. It keeps on going lower. The royalty rates decrease over time. And fundamentally, in the comparable analysis, the functions between the internal contract between Veritas and its Irish entity was comparable to third-party entities. The functions, the contract terms, the risks, and the property services. The only difference that the court found was in the economic conditions, that the economic conditions were not comparable, that the Irish entity is not a distributor in the same way that third-party entities would be distributing. But the court noted that even though there were some differences in the economic conditions, based on this benchmarking analysis, that didn't value as much as the functions and the contractual terms being similar. Looking at the contract terms, not just consideration, but volume and the types of sales that were being made. So overall, this shows that contracts in the US jurisprudence in Veritas were valued over the economic conditions. So this slide here should mirror the former slide. You have to look at licensing agreements, one intangible, the trademarks, the sales agreements. The court said you need to analyze these all individually. So you analyze them in year 1 and to year 4, there's a dramatic difference in how much they're worth. The trademarks, you can measure them over a year of time. The sales agreements, the court didn't actually come to a decision, but it fundamentally said they needed to be valued individually, not in the aggregate as the IRS proposed. And they didn't come to a decision on that because they said more data was needed in order to determine these sales agreements. But you can see here, there's 3 bullet points. These are just 3 examples of the intangibles being valued differently and individually. The IRS wanted to do them in the aggregate. The court wanted to look at them all individually and sort of rejects the IRS's approach to determining this. So overall, the gist of this case, I would say, is that you have this framework outlined in Veritas where you have to go through this step analysis and you have to value the intangibles. Not necessarily, you could do it in the aggregate, but you need to do it accurately. And in this case, the accurate method was not in the aggregate as the IRS had proposed. So it's interesting to consider the US tax court on the right here. We have the comparable, the sort of cavalcade of its interpretation. And to the left, you can sort of see the OECD framework that we had looked at previously. They take different approach. Indeed, step 2 is both like looking at the contract terms, but I think it's interesting to note that economic conditions are sort of lower on the list in the US tax jurisprudence approach than in the OECD approach, which seems to look at them at step 1. I'll briefly go into the 2 more cases, Zillinex and Amazon. I won't go into as much detail, but the nice thing is that if you look at read these cases, well, Zillinex follows and cites to the Veritas methodology that we had looked before, going through that functions, contracts, risks, economic conditions, and property and service analysis. Zillinex is looking at a different cost in this case. It's looking at stock options. Stock options are basically compensation that a lot of software companies provide their employees. You get an investment after a certain time. For example, if you work at company X for 5 years, you get, ABC amount of stock from that company. And it should be noted that these can be pretty big deductions that the US parent can take when an employee exercises their stock options. And the question was the valuation of this stock option accurate, and would it be comparable to other contracts? So in short, would a business deduct their employees exercising stock options? Would the third party, that is to say, deduct these contracts that an employee might decide to use at some point once they reach their target period for when they're able to use these stock options. There was sort of a deeper issue in this as well, that the US regulations are frequently very detailed as to which intangibles need to be analyzed from a risk perspective. And you frequently have the trademarks, you have discussion of whether research and development are discussed, but there was no explicit mention of cost of stock-based compensation in the regulation. So the court holds that, and this seems to make, as the court laid it out, the court holds that unrelated parties would not cover each other's stock options. This court said that it's very difficult to assume that a third party would cover the employee stock options of another third party. Indeed, you would never see that in a contract. And that's kind of the basis of this decision. The court heavily based its analysis on the contracts and where risk is allocated with contracts. And in short, you would never have non-affiliated groups paying these stock-based compensations. So this Zelenex case is a really good example. We follow the Veritas methodology, we being the court follows the Veritas methodology and bases their risk analysis based on contracts. Another case that also follows the Veritas methodology is the Amazon case. Amazon's briefly, Amazon entered into a cost-sharing arrangement with a Luxembourg subsidiary. In a series of these transactions, Amazon US gives the Luxembourg subsidiary right to use pre-existing intangibles, many of which were required to run the Amazon website in Europe. These included some intangibles such as software, marketing intangible, trademarks, domain names, customer lists, and so on, that type of information. Amazon valued that buy-in payment at about $255 million to be paid over a certain amount of time, and the IRS thought that it should be $3.6 billion. But the tax court sort of rejected the IRS's premise and found that the fundamental premise of this cost-sharing regulations were as previously held in Veritas. If you look at this quote here, I think it's worth reading because it sort of mirrors the Veritas language exactly. This is a quote from the Amazon case. By definition, compensation for subsequently developed intangible property is not covered by the buy-in payment. Rather, it is covered by future costs sharing payments where each cost-sharing participant pays its share of the ongoing and intangible development costs. So the idea is that you don't put these, you can't necessarily put them all together. And you can't use the aggregate approach, which is what the IRS had also tried to do in the Veritas. Also, the second quote is basically summarizes the IRS, what the court determined to be the IRS's error in Veritas. The court shows in Amazon, by valuing short-lived intangibles as if they have a perpetual life, the commissioner, that is to say the IRS, buy-in payment improperly took into account the value of intangibles that were subsequently developed rather than pre-existing. So this shows that in interpreting risk, the tax court rejects the notion that these intangibles have a perpetual life. As we showed in Veritas, they sort of ramp down over time, and you can't aggregate pre-existing intangibles and subsequently developed intangibles. So that's the Amazon case. And this actually came up in the case as well. So this was a nice diagram. The green circle are where sort of the US parent exists. And the red circle is where the US tax court saw risk allocated. And that's where it determined that risk should be allocated. If you can see this red circle is basically a Lux entity. I know this is kind of a grainy image, but it was worthwhile because this was actually right in the tax court case. And, outlined the Amazon entities in question. So fundamentally, the question is, where should taxation occur? Should it occur? The US tax court would probably see it down here. And based on the normative framework that we had discussed in the beginning, taxation under the OECD approach might appear up here at the green circle. So that's my presentation. I think I'm at 25 minutes exactly.
Which is great. Thank you so much. me as a listener to this, being part of the audience, I might be, and the rest of the audience might be a little bit puzzled on the whole discussion about the value of the transfer of the IP and the intangible in a discussion about risk allocation framework, and we discussed that in our before this session. So the puzzlement is interesting, because at the end of the day, what the risk control framework that is allocated, or risk allocation framework that is advocated by the OECD does, it says, well, hang on, we have here a Luxembourg company that buys into intangible property that is developed initially by a US company, but it does not only buy into it and then licenses that out, but it also buys into the future contributions that have to be made in order to further develop that intangible. And the interesting thing is that in all of the cases, I guess, what I remember is that in all of those cases, these buying entities, these purchasing entities, were empty companies, were sort of, well, empty boxes with no employees. So the question there was typically, okay, but if I have an empty box, how can that manage risk? And in the case law that was developed in the United States so far, that discussion, well, didn't take place at all. It wasn't even the approach of the IRS to say, well, hang on, guys, we here in the United States effectively manage and control those risks. So at least the buying company didn't. So that means that it must be somewhere else than in the buying company. And well, most likely would have been the US that did that. And the interesting thing is at least that the tax court didn't take that perspective and just, well, looked at rather at the actual contract, as you pointed out. My question is that a correct understanding of how the US case law works? So far,
well, I mean, it's interesting to say. I should have maybe marked out a passage from the Veritas case, but the Veritas case points out that there was it outlines exactly how many employees were in the Irish entity, and that they engaged in an aggressive marketing scheme.
Okay.
So I think that I shouldn't venture to say which is the correct approach.
Okay, yeah. but the question is, so in Veritas, it might have been that indeed the risk control was more with that Irish company than, for example, in Amazon. And maybe I'll address briefly also the whole Amazon case from a EU perspective, because the interesting thing about the Amazon case is that there's been two courts that have given their thoughts on the Amazon case. One is the US tax court, and the other is the EU grant court. So maybe I'll share my screen for a while, and I prepared something as well, which is actually a very simple scheme. You see it here?
You just have to go to slideshow.
1 second. Am I in still?
Yeah, we see this scheme, but not slideshow. But it's okay. We see the scheme.
You don't see the slideshow? Oh, I can.
That's fine.
We see PowerPoint kind of the user interface.
Is it now?
We see the slide.
Okay.
Mhm.
Well, that is always irritating. Anyway, what you see in the European Grand Court case is that, well, actually the same scheme as we have seen that Charles showed us. And what you see is that the US and the Luxembourg company entered into a cost-sharing agreement with the buying and cost charges, and those licenses were licensed. The intangibles were licensed out to a Lux OpCo, and the Lux OpCo licensed it out to the various operating companies. And well, the interesting thing here is that at least we know for sure that the Lux the Lux SCS, this company, AEHT, that didn't have any employees. It just didn't. And that was also the reason for the Commission to say, hang on, what happened here is that if we accept this Lux company as the recipient of that royalty income, it actually had a passive role in licensing out the IP, which it was basically a mere agent for receiving that income. So it didn't make any valuable contributions. Where the Grand Court said, well, also making available of intellectual property must be accounted for without any distinction between passive or active involvement. And the licensing of intangibles is an active function. And what the Commission also came up with is, well, this Luxembourg company, while it doesn't have the functionality to manage the contributions that it should be made, that it should make in the cost sharing agreement. So the future contribution to be made in order to further develop the license, well, it didn't have any functions to actually manage that. But the Grand Court simply said, well, no, also making financial contributions, even without having employees, is a real function that should be attributed to the. So what we end up with, if we are, is that the US and the EU Grand Court basically say it is the Lux company that should be attributed and allocated the income from the licenses. The OECD says, well, it might be that actually where the risks are being managed with respect to making further investments into the license was in the US. And the European Commission says it should have been here. So what we end up with, if we follow that framework that the OECD advocates, we end up with the possibility that you deviate from US taxation or tax courts, as well as European Grand Court tax courts, or which basically I say tax court, but which basically is not true, because it is, and we have to keep that in mind. At the end of the day, the Grand Court did decide on a state aid case, not on a tax case. So there is a difference there. And there is another thing that we have to realize, that both the US case as well as the EU case was issued and played before any risk allocation framework was introduced. So we get into all kinds of technical and even legalistic questions about what is the status of the OECD guidelines? Do they have retrospective effects and all those things? I think that is one of the additions that we have to make. I think we switch over again to Professor Tavares, Romero, maybe.
Yeah, and apologies for the technical difficulties earlier here.
Happy to have you back. We're happy to have you back.
Bit of a problem with my internet connection, but it was very interesting for me to hear the two of you also, because it was really hitting home the point that I was conceptually trying to make, but the examples just make it more vivid, which is I do believe, and I've been advocating that for a long time in my research, that there's this profound misunderstanding of the meaning of enterprise. Because what we refer to in Article 9 and what the guidelines attempt to do in transfer pricing is to deal with transactions among associated enterprises. And we took, in the context of application of that notion and of the arm's length principle, we took that one step further into the direction of, I say, a property rights view of what enterprise means, which is akin to legal personality. So we end up stumbling upon the boxes, the legal entity boxes, and equating the boxes to the enterprises, which to me is a legal shortcoming, but even more importantly, it's an economic shortcoming. It's a short-sightedness that we've had collectively for the past several decades, especially when businesses started to transform. So there was a moment in time in the past, and I try to highlight that in some of the publications that I've made, where a legal entity was a good proxy for a separate enterprise within the context of a multinational group. So given trade barriers, communication, distances, difficulties, etc., freight. So each, let's say, almost like country operated as an autonomous cell within a big body, but it was an autonomous cell. And from the viewpoint of economics, those boundaries of jurisdictions would often coincide with the boundaries of economic firms within these multinational groups. So for many, many years, we had a legal term and an economic term that, by reason of other facts and institutions and rules even, it ended up giving us the right answer, because we had separate enterprises almost coinciding with the separate legal entities that were transacting within a multinational group. So Article 9 would be coherent. It would make sense. When we moved into this world of connectivity of business models, integration of business models in a way, of the Amazons and so many others, it's not just the very high-tech firms, it's pretty much every multinational nowadays, where the activities and the, let's say, the high value-added services performed by people within firms are highly integrated and connected and almost 24/7. The boundaries start to blur. The boundaries between the separate legal entities and enterprises within multinational organizations, they start to blur. We don't know where one enterprise ends and where the other begins. But what I contend is that it's almost never is the boundaries of the legal entity. It's something in between. It's some combination, could be regional, could be segmented by a product line, could be segmented by market. But the point is that economically, this is very evident. So in economic theory, we can see that very clearly. Managerially, even I've went into let's say management theory as well, and it's even more evident in the measurement of performance and alignment of incentives and all of that. So it's even more evident. Accounting-wise, managerial accounting, it just takes different shapes and forms according to what the business actually might be. And when we go back into our world of the legal rules that use economic language, and this is where it gets very confusing because it sounds like economics, but it's not. We're still dealing with rules. So the legal rules that use economic language, they use the right term in my view, and I defend, which is the term enterprise. And even the very old model convention, when it defines enterprise, it defines it as the carrying on of a business, which could be a legal entity, could be a branch, could be a factory, could be whatever. But the point is that legally, we have that leg room to acknowledge an economic firm. We're not bound by the form of the legal entity in determining what the enterprise is. So a lot of the problems we see in real life and that we saw in the cases here was because of the separate boxes. We were trying to make the boxes fit the term enterprise. So if I have this Lux box with cash but without people, is the financial capacity to bear risk then there, but not the capacity to manage the risk afterwards for the continuing cost-sharing payment. So we start to apply our rules, in my view, to the wrong enterprise, because we're applying it to the box. One step before, which is, again, in using even the wisdom and the language of the guidelines, if we were to delineate the transaction, understand the economic conditions, we would probably be able to identify who the parties were. If we're able to identify who the parties were, perhaps they're not separate, even though there is a property rights view of separate ownership of assets within the group bound by the legal entities. So to what extent those contracts need to be tested vis-a-vis the reality of the transaction. Contracts meaning even the articles of incorporation of firms, of legal entities. So I think that this is where we end up getting lost. I think we're getting there, because when I see a lot of the debate that's been happening between us academics in different continents, and I see what's been debated also in courts in these cases, I think we're scratching the surface. I think we're hitting the pole, to use a soccer analogy. We haven't scored the goal yet, but we're hitting the pole. We're almost there, because I think that we are not satisfied. None of us is. The courts are not happy. The authorities are not happy. Firms know that they are facing uncertainty, so they can't be happy. I mean, they can be happy if they're paying less, but they shouldn't be happy if it's not sustainable, right? So to the extent that it's uncertain, and to me, that's the best definition of risk, since we're talking allocation of risk, it's uncertainty, right? It's not downside. It's not knowing if there's an upside or a downside. That's uncertainty. That's the best definition, in my view, of risk. So to the extent that we're dealing with uncertainty, we're dealing with risk to everyone, treasuries and firms. And in my view, if we go back to the basics and back to the foundation and try to understand and look again on what the object of the rule is, which is enterprises, then we should be able to apply the rule and apply the framework and apply the methodology and arrive at an answer that makes sense. Otherwise, we will end up finding more and more cases such as those we've heard, where we say, well, this is just perhaps a venture capitalism view of the world, where cash is king, and if I have the money, I make decisions on how to apply the money and invest. That's enough. So the board rules, right? The board rules. Whereas everybody down below is just a bureaucrat, just working these, right? So people functions are not that meaningful, which is a very US way. Under 42, it's a very American way to see the arm's length principle, not as the principle, but as a standard, like they like to call it. Whereas if we go back into where the guidelines have been evolving or have been, not linearly, but stumbling, but getting there, it's the value of people. This notion of value creation, as fuzzy as it is, I agree with Rutger, as ambiguous as it is, once it incorporates the term creation, it implies activity. And in my view, if we're dealing with activity and creation, we have to be dealing with people in some way, shape, or form. So I think this is where we are limited right now. We don't have the answer. We don't have the final answer. But I think that this is the source of the questions that we identify in the race. And the good questions we ask ourselves and we see courts being asked are about these limitations. To what extent are we still applying too much legal fiction to define economic terms that are in the law? Or when will we be able to interpret the law in its economic terms using economic science, economics? I think this is where we are right now. And if I go, just to close, because I know that we're almost there on time, but to move into the Brazil commentary, if I go into what Brazil has done since forever, was Brazil wanted to stay away from all of this discussion. It was too uncertain, it was too risky, it was too difficult. Perhaps it was too sophisticated at one point. Then it was not about sophistication anymore, it was about uncertainty. But Brazil said, fine. So I like the notion of the arm's length principle. I like the rule of thumb that can be used to prevent abuse even. So this was the, let's say, the inspiration for the old Brazilian rules. But I really don't like what I need to do and the uncertainty that is involved in ascertaining what an arm's length price might be through comparability, function analysis, and so forth. So I don't want any of that. I don't want the toolbox. I like the principle, but I don't want the toolbox. So here's another toolbox. So for 25 years, Brazil came up with this system of presumptions, right? So I would have a preset, let's say, I'll call it functional profile. It's a full risk distributor. It's a licensed manufacturer, but with a lot of risk borne locally. So there was a lot of preconceived notions of what firms were in Brazil, in the real life of the Brazilian economy being very large and very closed, which influenced how the principle could be applied in a simplified way, you know, through I don't want to call it safe harbors because it was not so safe, but through a series of set presumptions, objective presumptions set by law. It's not just a fixed margin, it's also a fixed functional profile, even though it was not called that way. So Brazil had for 25 years, basically a very broad and very difficult to apply cup. And then it had a cost plus and a resale minus with tweaks and turns on whether it was on the import side or on the export side. It had a very broad net in terms of what transactions it tested and under the the rule, covered by the rule. But at the same time, given that it was setting up this, let's say, rigid set of presumptions, it decided, the Brazilian authorities and Brazilian law in Brazil decided to forego on the most adequate method or best method analysis and say whichever method can be used to support that it fits in an import or on an export, any one of these set of presumptions is good enough. So this was a way to balance the system in a way and to say, yeah, we're still aiming at getting somewhere at arm's length, and we're still just trying to prevent abuse. We're not trying to find the truth because we don't believe the truth is very much discoverable because it's too difficult to get there. So this was, at the same time, the wisdom. At the other, on the other hand, the laboratory that Brazil has put itself into for 25 years. Basically, one of the problems with those presumptions was that it really has become a self-fulfilled prophecy. So in a way, if you had a business that was very high risk, very high in functionality on the ground here, probably the rules were in a way favorable, were generous. Probably the rules would require less margin than you would otherwise be getting to applying the OECD guidelines. Whereas if you had a business or a business model where there was limited risks or a commissioner, a service provider, whatever, then the rules would always be terrible. They would always be very difficult, very burdensome, requiring more profit than would be arm's length. So in a very broad way, Brazil did that, and it ended up shutting itself out from bits and pieces of global value chains, where you could have, low value adding services, low value adding functions, contract manufacturing, toll manufacturing, whatever. So Brazil ended up not taking part in a lot of the globalization that took place for many reasons, but one of the many reasons being double taxation on those low functionality type profiles. And on the other hand, for Brazilian multinationals that were expanding with headquarter functions sitting right here in Brazil, what did you have? You had an incentive for profit to be shifted abroad, because Brazil would not test the arm's length nature of those transactions between headquarters and all the different legs and arms around the world, and would tend to be generous in requiring perhaps less profit than what would be arm's length in those transactions. So you had Brazilian multinationals mainly inflating P&Ls around the world, and on the other hand, foreign multinationals having difficulties with the Brazilian market unless they were very heavy capitalized, very heavy functionality in the country. So it ended up being, shooting, both foots with the same gun. So Brazil ended up not getting the right answer on both flows of foreign direct investment. Investment going out, having a tax subsidy to go out. Investment that could come in, having a tax barrier for it to be as high as it could have been. So it was not good for Brazil in the end, this experiment or this pilot of what perhaps a simplified approach to the arm's length standard could be. So a very, very early dream of a pillar one, perhaps, is what Brazil tried to do. In the end, because Brazil wants to accede to the OECD, and because the process started in 2017 with feedback from the OECD saying we cannot even start negotiations if transfer pricing doesn't fit, Brazil, of course, took the necessary steps with a lot of support from some countries like the UK, the US to a lesser extent, but the UK to a huge extent, also Spain, also Mexico. So a few countries around the world were, behind the idea of Brazil getting there, and have collaborated very much with Brazil in documenting, in showing these two effects that I was talking about. How Brazil was shutting itself out from global value chains in terms of non-Brazilian capital that was moving around, and how Brazil was subsidizing Brazilian multinationals with a tax break and inducing them to do BEPS around the world. So all of that was evidenced, it was documented, and by the end of 2019, the Brazilian authority, which until then was very proud of a system that it felt was bulletproof, in a way, BEPS proof, it ended up saying that it was not. It was hurting Brazil on both ways, but it was definitely not BEPS proof. So because of that, the decision was made. Brazil decided even back then, right before the pandemic, to go ahead and develop legislation which would fully adopt the OECD guidelines. So not US style, but a blend of continental European versions of what the guidelines materialize in legislation. The pandemic came. We were, of course, with many other priorities and difficulties the last few years. The project jump-started again last year, and then earlier this year, the decision was announced that the legislation would come into effect this year. And we're still waiting for that law. So Rutger, sorry to not yet be the new kid on the block, but I'm waiting around the corner. But that law should be hitting Congress this year. What we don't know is that given how late it is in the year, and we have federal elections happening, if it's going to pass and take effect in 23, or if it's only going to be voted in 23 and take effect in 24. But the point is, what we will see there in the presentations and discussions we've had publicly with the authorities here is distant from what you see in the US and closer to what would be perhaps an European Commission's view of how the guidelines should operate. So a lot more driven by substance, a lot more driven by activity, by people, a lot less driven by contractual forms. So again, let's see, because it's difficult even to draft this in detail. If you want to move away from the safety of contractual form, it's very difficult waters to navigate in. But we hope, given the amount of consultation and support that was given to the authorities, we do hope that there'll be something sensible. And as I said, perhaps something closer to what you see the average continental Europe, large continental European country doing. So hopefully I'll have some more news for you within the next couple of months. But implementation is definitely forthcoming, if not in 23, certainly in 2024.
Thank you so much.
I'll give it back to you.
Thank you so much, Romero. I think you have both Charles and you, Romero, have given us a lot of information. One of the things that triggered me during your presentation was, I think, the concept which you brought forward, and I guess that is quite enlightening. The concept between that there is a difference between a box and an entity. And there used to be in the past, it was quite coherent, but it has well diverted over the past years. Well, then if you even go back to history, then it's even more interesting to see, because well, the whole concept of a limited liability company in as such is an interesting concept. The concept that you have a piece of paper to which you allocate all your, or attribute all your actions is an interesting concept. Having said that, the difference between box and enterprise, what triggers me is, first of all, have we seen it all wrong from the very first day? Did we mix up things in the very first day? Because if you look at Article 9 of the OECD, it doesn't talk about entities. It talks about enterprises. So that means the interesting thing is that, have we all just mixed it up because in the past there was this, well, coherence between, and we didn't have that much of a problem. You had an entity, and that entity wasn't, was just the same as the entity was the same as the enterprise. So the strange thing, however, and maybe that's also a question, do you think that if we just reinterpreted Article 9, or reinterpret, basically go back to its basics, and say, well, look at what the wording is. We just it is in a treaty that aims to allocate taxing rights, and as we all know from the very first day of international tax law, taxing rights, it does not provide any obligation to tax. It allows you to tax, and well, if you have an enterprise, you are allowed to tax it, whether it is a company or whether it's a partnership or whatever you have. It is just the enterprise. So do you think that the current interpretation of Article 9 already allows to deviate from the entity approach?
I actually do, Rutger, and this is what I've been writing. What I believe is that there's a distinction there between the terms of the rule and the interpretation that is in the commentary. If we look at the rule, if we simply look at the definition of enterprise in the definition article of the treaty, if we look at then Article 5, and then Article 7, and then Article 9, call me Viennese, but I see beauty. I see a coherence there, which can be interpreted economically quite well, and again, with proper legal foundation. When you look at the commentary, though, under each one of those very fundamental articles, you see a hodgepodge in a way. It's like patchwork. You see different commentaries coming in different points in time, and when it was loose leaf, it was easier to identify. Now, no longer. But clearly, there were trends of thought or consensus or negotiation in coming up with the words that would be used for the commentary that in a way undermined the interpretation of that rule. So when we look at the commentary, the way it's posed, some paragraphs of the commentary would allow this view that I'm suggesting here. In my view, the rule itself clearly does, but the commentary in some parts is absolutely consistent with this view that I have, but in some critical parts, it's not. It ends up using the entity as a proxy for the enterprise.
And the strange thing is even further,
creating...
Romero, because when I have my lectures on transfer pricing as well as on profit allocation for permanent establishment, I discussed it, well, the whole rule of saying, okay, we started off with this fiction of an entity, which is actually, if you go back to, well, history, it is a strange fiction. It is started only somewhere back in the 15th century, and before that we didn't have that concept, and now we have, and now we are so accustomed to it that we find it difficult.
We can't let go.
We find it difficult to tax permanent establishment as if, and we think we should do that as if they are entities. At the end
exactly.
Of the day,
we are addicted to Article 9, where perhaps we could be doing more Article 7.
Yeah, and addicted to Article 9, if you reinterpret it, and then that's my next question maybe also. I have been always very critical of the risk allocation framework. The reason not being exactly for the aim or the objective that it achieves, try to achieve, but rather that it fits very difficult within what we know so far. And the strange thing is that the OECD has taken the view of this risk allocation framework, which creates its own strange fictions and own strange things, whereas your explanation of, well, we just go back to the very basis and say, what do we have here?
What's the enterprise?
What's the interpretation of action? It's talking about not entities, it's talking about enterprises, and what is the aim of the whole, well, double tax treaty is to allocate taxing right and not how you do it. Have another question on that is what we see is that the whole concept of transfer pricing in most countries is it comes up in a corporation tax. In the Netherlands, we have this problem is we have a corporation tax and the corporation as such is taxed, and even the legal basis for a corporation tax is sometimes a little bit difficult, because how can you tax a corporation that is just a piece of paper? So conceptually that's difficult. But how would you think that fits into that allocation if you took your view of, well, it is just an allocation of taxing rights for the enterprises?
I think it fits the way it was intended, I think, in the design of the rule, which is you would have a broader Article 5 and 7. And then in that broader Article 9 and 7, you would have these different enterprises. And then, of course, these different enterprises would be transacting with one another. So you go back to Article 9, but on a different basis. So you end up
you
applying
take the enterprise and not the box. Yeah.
Exactly.
Yeah.
Exactly. If you consider that much in the same way that the risk framework is doing with the transactional contracts, if we view the articles of incorporation as one more and say, let's understand what the enterprise is. And I'm not innovating in saying that, because that's been in the model convention since the beginning, in a century. We just forgot it's there, right?
Okay.
So if we basically say, let's try to understand what the enterprise is for purposes of understanding where there is a permanent establishment, and let's not get boggled bound by the proxy that the existence of a sub doesn't mean that there's a PE, because that's a rule, right? The point is that what activities are performed in the country, what decisions are made that are not just for that one separate piece of business, and to what extent this commonality of management, as you said, from the other session that I was not a part of, where decisions and even control over risk is done bilaterally, trilaterally, multilaterally. Does that mean then that the enterprise touches those 3 or 4 territories? Because if it does, then before we talk about Article 9, we have to talk about 5 and 7 and figure out what that is. Then to the extent that enterprise in that configuration transacts with another, we go back to the old Article 9. But under both, I'm allocating at arm's length. Basically, that's my reading of the old rule, even though that is inconsistently portrayed in the commentary. Some parts of the commentary, you can see it, you can smell it, you can feel it. In some parts of the commentary, you very clearly see stop signs saying, don't go there.
Yeah, exactly.
But because it's all interpretation, it's not the rule. That's why I think it's easier to change than coming up with an MLI. It's easier to do than Pillar 1 and Pillar 2, I think.
Yeah. It's interesting. Yeah, I think it's a very interesting view. Charles, you have anything to add that from a
I think Svetlana seems to have a question there. She had her hand raised.
Svetlana, please.
Hi, thank you so much for very interesting presentation. So my first question would be also to Romero. The first one was that in principle you advocate for a more economic view, and as for I understand with these multiple layers of risk control, it would be more for more apportionment, something like that. So for the and also create a new permanent establishment that also would need to develop some proxies as well. So how much you are satisfied with the current projects on that? So with Pillar 1, Pillar 2 on one hand, so I would say that they're not going to have a new permanent establishment. Indeed, it's a market jurisdiction in case of Pillar 1. And it's a bit different, indeed, but at the same time, it reallocates residual profits that we used to allocate mostly to risk function. And now market countries taking like some portion of residual profits. So what would be your view on how this framework actually should proceed with taking into account risk control framework, and also maybe some points to enhance this in the future? Thank you.
Yeah, thanks for the question, Svetlana. I mean, to make a long story short, I think that not all roads lead to Rome. We all want to go there, but not all roads lead there. What I think the entire initiative, was aiming at is something very needed, very important, which is first getting to the right answer, but second, getting to consensus. Doesn't matter if you have the right answer that nobody agrees to, because then you have war. So to the extent that you can have consensus over whatever rule, you minimize the risk of double taxation, pluritaxation, etc., which is good. And you also minimize the risk of non-taxation. So from that perspective, I've always admired, very much supported the initiative. From a purely conceptual point of view, I don't like the approach, because I think that the approach is another proxy. If I believe that we're attempting to tax income, business profits, I go back to the definitions of the treaty. If I say I'm trying to tax business profits, I'm not trying to tax trade, I'm not trying to tax consumption, even though a consumption tax and an income tax are two branches of the same tree, right? From a personal tax point of view. But if I step one degree away from the individual payer of the tax, and I go back into the scope of the business profits rule, which is what we've been talking about, I'm talking about the corporate tax, the corporate income tax. And if there's a withholding tax, it's an in lieu tax. It's a substitute for the corporate tax. So if I'm in that world, which is not the same world as the world of VAT and the individual personal income taxes, then I think that the route taken was technically not the best. Why? Because the proxy chosen for business profits, which is the location of the consumer, might be a proxy for a certain portion of normal profits, but I am not convinced that it is a great proxy for residual profits. And at the same time, to get to use that proxy, you end up using a formula. And that formula might deviate from the principle. So it might become just what I believe has become negotiation. So if you have a principle debate, are we trying to come up with a proxy to the arm's length principle? If we say yes, then negotiations are framed and guided. It's not about who wins and loses. It's about trying to get to the best possible or the second best possible answer for everybody. So in a game theoretical sense, when you're principled, it's easier to resolve the dilemma. When you go back to the situation where we just know we want to tax and we elected this proxy, which is consumer location, because it makes sense in the world of data, blah, blah, blah. But if we say that the proxy is there and the political will to tax is also there, but there's no principle in terms of how to define the base, then you go back to the world of CCCTB or whatever. It's what is the formula? How are we going to divide it? What is the rate? So you end up, in a world of bargaining. In a world of bargaining, it's much harder to do in a game with so many players. So if you have 3, 4, 5 players, maybe you get there with just bargaining. If you have 27, like in Europe, maybe you don't. But if you have the inclusive framework, very difficult. And then perhaps you end up getting somewhere just for the sake of having achieved something, and it's too high level, and you end up having disaggregated interpretations and answers nonetheless. But the point is that if you do all of that, and you do that by choosing a proxy and having the will to tax, but not being sure that that proxy is a good proxy for business profits, what you might end up doing, you might be creating a consumption tax, period. So this is the concern that I have with respect to Pillar 1, is that if you don't develop it in a bit more principled way or in a deeper way, you may end up with it simply as a quasi VAT dressed up as a business profits tax to appease the public. Whereas in Pillar 2, the global minimum tax, etc., it started off, in my view, as a bit more principled because it was, okay, let's fill action 3. So let's, CFC didn't solve it. Let's come up with something else which solves it at the top. So the top-up tax. When we were in the world of the top-up tax and the threat of, if you don't do a top-up tax, somebody else will, then maybe we would get to coherence also for those rules. It's not transfer pricing, it's not risk allocation, but we would get perhaps to a good answer for CFC. Now, if we deviate from that path and we end up in a world where there's different kinds of rights to countries that may not be base eroded over residual profits. So the under-tax payments rule, now it's just an under-tax rule. It's no longer under-tax payments rule. So if you move away from the payments nexus to jurisdictions, you end up in the world of politics again. So I'm a bit disappointed, I will say, in how the whole initiative developed. I love the way it started. I love the goals. I admire the effort, but the way that it's materializing right now in the last stretch, in the very end, to me, it's becoming too political and not principled enough. And then again, not consistent with what I think risk allocation and business profits should be. So I'll stop there. Otherwise,
thank you so much. I mean, it is. I'd love to have some lectures from you, Romero. So thanks very much for the very extensive answers. I think we can. My takeaways of the whole session that we're approaching an end to is first of all that the US as being, well, the cradle of transfer pricing, historically has been the cradle of transfer pricing, has developed its transfer pricing practice very well along the lines of the sort of traditional separate entity approach with a huge focus on contracts, which is historically very well, as you pointed out, very well understandable. And what we all seen is that that system as such has become problematic. And I think the US, by the way, in itself has had made its own adaptations to the system. For example, in the guilty, we won't go into detail on that, but eventually it ends up with a sort of an OECD outcome, at least for intangible income from intangible property. But it remains as a starting point pretty much. It hangs on to the system of the separate entity approach. We see the same happening in the European Union with the Grand Court. It also pretty much hangs on to a quite a legalistic system that adheres to contracts and rather than to the risk allocation framework. It might be that those tax courts in the US as well as in the EU are, well, they are typically lawyers, so they typically start off with the traditional legalistic type of reasoning, whereas I think, Romero, you provide also a very interesting different view on that and say, well, if you want to keep legalistic, just then read Article 9 and go back to its origins, and you are there, and then you clearly have to think about a new framework. I think we are approaching the end of this webinar. We aim to be really on time, so we are approaching 5 o'clock now. I want to thank all of you, Charles, for being so kind to as one of the former students to help us out and to enlighten us on the US from a US perspective. Romero, with your very well, I think you demonstrated very well that Brazil is a really a valuable new kid on the block with some very great ideas. I've not seen any questions coming in from the audience, which hopefully is because I think both speakers were extremely clear, which I think at least was the case. So thank you both. Thank you also, Svetlana, for making this project, well, enabling this project, making it possible. We last final remark is we have a next seminar that's coming up in webinar actually, 23rd of November. That will then I will be a panelist rather than a moderator. So we're looking for a moderator still. Maybe some of you will like to do that together with Emmanuel Hilaris. And then we will go into, well, base ourselves on the existing framework, or at least the existing conceptual framework based on the separate entity approach. But we will dig into a little bit on how you can support your risk analysis with some numerical analysis. And we will discuss correlation between risks and routine and residual profits, how you make a risk analysis not just a simple list of risk involved, but how you can enhance the quality of your risk analysis by doing some economic risk evaluation techniques, and how to make options realistically available, comparable by analyzing the risk of each option, which is a more of a technical session, but I think very important to address in this series as well. Again, thank you so much to all the speakers, Romero and Charles and Svetlana, and to the audience. We count on you being back on the 23rd of November.
Thanks again.
Thank you very much.
Nice being here with you all. Bye now.
It's been a delight. Bye.
Thank you.
Mm.